There comes a time in business when a client just won't pay, despite your invoices, reminders, and even demand letters. What can you do? You've got legal options to recover what you're owed. Let's walk through them. First up, prevention. Before things go wrong, you can minimize risks. Pick creditworthy clients, do credit checks, have clear terms, conditions, and defaults in writing. Manage your clients, manage credit, send invoices fast, follow up on overdue payments. All of this can reduce the need for legal action later. If the debtor still refuses, start with alternative dispute resolution, or ADR. That includes negotiation, mediation, conciliation, arbitration, and adjudication, for example, in the construction industry. These methods often cost less, happen faster, and preserve business relationships. If ADR doesn't resolve the issue, your next step is to commence proceedings in court to obtain a money order. That means filing and serving a claim and statement of claim. The debtor has typically 28 days to respond. If they don't, you may apply for default judgment. There is also summary judgment if they do respond, but the defense doesn't have any real prospects of success. But courts are strict with summary judgments. They're only granted in the most clear cases. Once you've got a judgment or an enforceable money order, enforcement is the next phase. You may use enforcement warrants, so seizure and sale of property, redirection of earnings, charging orders, for example. If the debtor is a business, sometimes a statutory demand or winding up application may be available. If it's an individual, bankruptcy may be an option. Keep in mind, legal recovery takes time, cost, and effort. It's always better if you can settle early. Letters of demand are often the start. Litigation comes if you have to. Also, be aware of time limits. In Queensland, you have 6 years from when the debt is due and payable to start legal proceedings. If you wait too long, you may lose those rights. Here's what to do next. Document everything. Emails, contracts, invoices, reminders. Know your costs. Calculate what you're spending chasing the debt. And if things aren't moving, get professional legal advice early. If you need help figuring out which option is right for your business, whether ADR, court enforcement, or insolvency routes, reach out and get tailored advice and a free 30-minute consultation with our debt recovery lawyers.